All right, just like I've said, that provision is very, very encouraging. It is very, very good. So it enables the indigent to enjoy their constitutional right of appeal. And then when we talk about the procedure for commencing criminal appeal, so I prefer discussing that under criminal litigation. By the time we are doing criminal litigation, I will talk about that. But so far, so good. We have been able to look at the procedure for commencing appeal and some of the nitty gritties that we need to know concerning appeal. But let me end here by giving us some authorities that will help us on the time to file appeal from interlocutory decision in pre-election matter. Pre-election matter being sui generis has time limit for the appeal. So the case of PDP against Lawal is reported 2023, 12 Nigerian Criminal Law Report, part 1898 at page 205. Page 205. So here the Supreme Court stated the rules. The Supreme Court said the implication of the compiled provision of Section 285, subsection 8 and 11 of the Constitution of the Federal Republic of Nigeria 1999 as amended is that an appeal against an interlocutory decision in pre-election matter can only be instituted at either the Court of Appeal or Supreme Court, as the case may be, after the delivery of the final judgment in the case. The provision of the two subsections ought to be read together so as to avoid defeating the object and the intendment. Then I will still go ahead and talk about what if in an appeal you have already filed your brief for 5 union and you suddenly remember that there is need for you to argue a fresh issue. You have a need to argue a fresh issue. Let's see what the Supreme Court say we should do when we are faced with such issue. That's talking about the case of Adie against the state. Adie against the state is reported 2023, 8 Nigerian Criminal Law Report, part 1887, page 591. Page 591. Here the Supreme Court said, where a party seeks to raise on appeal an issue not raised before the trial court or the Court of Appeal, he must seek leave of court to do so. In this case, not only did counsel for the appellant not attack Exhibit 1 on any ground at any stage when it was tendered, there was no ground of appeal challenging the admissibility of Exhibit 1 and no leave was sought. So in this case, the counsel sought to raise objection to the admissibility of a document, which he did not do. He didn't raise the objection at the lower court. And the Supreme Court said that you didn't obtain leave and it is too late in the day for you to raise the objection. And then restating the rule on admissibility of documents and whether objection can be raised on them on appeal, the Supreme Court said that where a respondent had the opportunity to object to the admissibility of a document and failed to do so, he is not allowed to object on appeal. He is not allowed to object on appeal. All right, you also remember that I did talk about concurrent findings. So because of time, I'll also go straight. I've already explained concurrent findings, but I'm going to tell us the rule. The attitude of Supreme Court to concurrent findings. Still the case of Adie against the state, Supra. Adie against the state, the Supreme Court stated, concurrent findings of facts of the trial and appellate courts ought not to be disturbed or set aside on appeal unless such findings are manifestly shown to be perverse or occasion a miscarriage of justice or a violation of some fundamental doctrines of the law. In the instant case, no exceptional or special circumstances were advanced by the appellant. In other words, a party who has lost his case at the High Court and the Court of Appeal and seeks to appeal, especially on the grounds of appraisal, non-evaluation or improper evaluation of evidence, the Supreme Court has an attitude. That is a general rule. The general rule of the Supreme Court is not to interfere with such a judgment. But if you want the Supreme Court to interfere with such a judgment, you must be able to show the Supreme Court that that decision was perverse and it resulted in miscarriage of justice against the appellant. Then again, too, I did mention cross appeal. Cross appeal. We want to look at what is the meaning of cross appeal. What is the purport of cross appeal? So here again, we look at the decision of the court in the case of APM against INEC. APM against INEC. In this case, it was held that a cross appeal is a separate and independent appeal from the main appeal. It has a life of its own. Where a cross appeal succeeds, the proper order to be made is to strike out the appeal instead of dismissal of the appeal. So a cross appeal is just like a counterclaim. It's just like a counterclaim, which is a separate action but founded on the same action, on the basis of the facts of the same action. Now, I did talk about formulation of issue. What is formulation of issue? After you have filed your notice of appeal, you have raised maybe many grounds of appeal. Now, in filing your brief of argument, where you're going to be selecting those grounds of appeal to be arguing, you're going to couch issues for determination. And when you couch issue for determination, like I have said, you relate them to particular grounds of appeal. You tie them together. You understand? So the authority for that is the case of Uzo Ukwu against Idika. Uzo Ukwu against Idika. Uzo Ukwu against Idika is a Supreme Court decision reported 2023, 3 Nigerian Weekly Law Report, Part 1818, page 403. Part 1818, page 403. The Supreme Court here held a ground of appeal from which no issue is formulated for determination by a party is clearly deemed abandoned because it is not tied to anything and has no sway in the determination of the appeal. So make sure when you formulate your ground of appeal, it must find its way to link up to any of the issues for determination. If not, if it cannot be linked to any of the issues for determination, it means that you have done what? You have abandoned it. And the court said in the instant case, no issue for determination was forged out from the ground 3 of the notice of appeal. So every ground must be useful to you. So find out how to tie your grounds of appeal to the issues so formulated. And then, okay, and there's something I want to point out finally here. When you have filed your brief of argument, the respondents will file what is called a respondent brief. And if you read it and feel that there is need for you to file a reply brief, which means if there is any fresh issue of law that they have raised in your respondent brief, which your brief, in their respondent's brief, which your brief of argument has not covered, then you will be entitled to file a reply brief. Now we are going to look at the effects of failure to file brief of argument or reply brief. Failure to file brief of argument or reply brief. This is also another Supreme Court decision. This is the case of Refuge Home Savings and Loans Limited. Refuge Home Savings and Loans Limited against Garakua. Garakua is spelled Garkuwa, is reported 2023, Part 1897, page 175. So here the Supreme Court relying on the old rule, that's the old Court of Appeal Rule 2011 said by virtue of Order 18 Rule 10 of the Court of Appeal Rule 2011, where an appellant fails to file his brief within the time provided for in Rule 2 of the order or within the time as extended by the court, the respondent may apply to the court for the appeal to be dismissed for want of prosecution. Now, if the respondent fails to file his brief, he will not be heard in oral argument. Where an appellant fails to file a reply brief within the time specified in Rule 5, he shall be deemed to have considered all the new points. Let me quickly explain this. 1. If after filing, having your record of appeal transmitted, and you fail to file your brief of argument within time, and without bringing an application for extension of time to file it, the respondent can be free to do what? Go to Court of Appeal, file an application to have the appeal done or dismissed. Now, if you have filed and the respondent doesn't file, no problem. But the point is that they cannot reply. They won't have any, nothing to argue because the court can't even allow them to come there and, do an oral argument. Every argument must be by way of brief. But if, on the other hand, you file your brief of argument, respondents file their respondent's brief, you're entitled to file a reply brief challenging the fresh issues of law that they have raised. If you fail to so respond, it will be taken that you have done what? You have admitted all those fresh issues of law which they have raised. But there's one thing about that rule is that most of the times, if those fresh points of law have no effect on your brief, the Court of Appeal cannot, because you have not filed a reply brief, fail to do justice in that matter. So far so good. We have come to the end of the class. Thank you very much for staying tuned. Thank you.